All right, this is a second-degree felony, ma'am, which carries with it a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you are charged with and the punishment range here? In summary, it alleges that on or about April 7th, 2025, in Jefferson County, Texas, you committed the second-degree felony of assault on a public servant by intentionally, knowingly, or recklessly causing bodily injury to the officer by striking the officer in the face with your hand.
A Texas courtroom suddenly takes a tense turn when a woman, once doubted for her mental fitness, is declared ready to stand trial. But what she's accused of is serious. A deal is placed on the table, one that could change everything. It sounds like a way out, but it comes with conditions that aren't as simple as they seem. Judge John Stevens gives a warning that chills the room: one mistake, and everything could collapse. Now the real story isn't what she did. It's what happens next. Backhand index pointing right. Will this be her way out? Or the beginning of something much worse?
Knowing that the complainant was a peace officer who was lawfully discharging his duties in arresting you for an offense. You understand? An agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. There would be terms and conditions of probation, which are normal and customary for probation. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this charge, guilty or not guilty? I'm sorry?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
So,
State's Exhibit 1 tendered?
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. It states so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived here.
Yes, please.
If nothing, and again, how do you plead to this? Guilty or not guilty?
yes,
And you're pleading guilty voluntarily and because you are guilty.
yes, sir.
All right, I'm going to find that you are mentally competent to enter this guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this second-degree felony of assault on a peace officer. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice, in other words, prison, for a term of 10 years. That will be suspended. You are placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense, not the least of which is, I'll bet you, anger management. Yeah. Great minds think alike. Among other things, you're going to have to complete an anger management program. Have you completed your high school education?
No, not.
You're going to do it on my watch. That's important that you graduate. And we're going to order you to complete your GED equivalency so that you can have opportunities in the future to become independent and make a living. All of these terms and conditions of probation, I'm going to give these to the probation officer. He will go over with those. If you fail, your probation could be revoked. You could be sentenced up to 10 years in prison. So it's important you follow those rules. You understand what has happened today, man. Good luck. Thank you.
Judge John Stevens' decision was not just a legal ruling, it was a balance between accountability and opportunity. On one side, there was a serious charge, assault on a peace officer, which usually leads straight to prison. But on the other side, the court also saw that the defendant is now mentally fit and may finally understand the consequences of his actions. So instead of sending him directly to jail, the judge gave him a structured second chance, probation, anger management, and education. This decision feels more like guidance than punishment, but it also comes with a clear warning: one more mistake, and the 10-year sentence could become real immediately. Now everything depends on whether he uses this chance to truly change his life, or just lets the time pass. Do you think Judge John Stevens made the right decision by giving probation instead of immediate prison time? And in cases like this, should rehabilitation matter more than punishment, or should the law be stricter from the start?
In summary, sir, this motion to revoke unadmitted and probation filed on November 7th of 2025 states that on December 9th of 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, a third-degree felony. Is that true, sir? Allegation? There are 11 allegations. What does the defendant intend to plead to, and what? Pleading through to anything?
I'll take responsibility, on what I did, but as far as me being drunk, sir, I was not.
No, there's, okay, number one states committed the offense of assault by threat on or about October 24th, 2025 in Jefferson County, Texas. Number two states you committed the offense of public intoxication. Number three states you committed the offense of criminal trespass.
Yes.
That's,
I'll tell you why.
no, that's okay. Is that what you want to plead to?
Well,
Is that what you're intending to plead true to?
yes. I fell asleep on the bench outside the restaurant. That's it.
Judge, can I put some things on the records, please?
Yes.
Okay. My client's already been sworn in, but I just want to make sure you understand what we're here for today and all your potential options. So you understand that you were put on deferred adjudication, probation, deferred or unadjudicated probation for evading arrest with a vehicle, right? And that's a third-degree felony.
Yes.
So the range of punishment for third-degry felony is anywhere from 2 all the way up to 10, with a fine not to exceed $10,000.
Yes.
So whenever you were put on that deferred probation, they let you know that finding of guilt was deferred for the period of probation. And if you completed it, it would be dismissed, wouldn't stay on your record. Is that right?
Yeah.
But if there was a violation, they could come back and revoke that probation and then give you a conviction for the offense. So now that we are here at this stage for a motion to revoke probation, you kind of have 3 options on how to proceed, and we've talked about what those options look like. Is that right? Sorry, she just has to take down everything that you say. So one of those is going through with a contested hearing where the prosecutor would have to prove the violations against you by a preponderance of the evidence. And then if they do that, judge could revoke your probation and sentence you anywhere within the range of punishment for a third-degree felony. Is that right?
Yes.
You understand that option? You understand another option is to voluntarily plead true and go agreed to a resolution with the prosecutor, which he's offering a resolution of 4 years. Is that right? We've talked about how he's offering the resolution of 4 years.
Did you know that?
Yeah.
Did you have enough time to think about it, though, and consider it?
Well, I believe on 4 years, wants to 4 years time for this, sir, but.
No, nobody wants to do a day, but I mean, that was.
I understand. I understand.
When did you find out about the offer from the state?
I found that excruciating.
No, when did you find out about it?
The first time I came to court.
Okay, so you've been considering, you've had time to consider it. Okay, that's, I just don't want to rush it. You have a fair, reasonable amount of time to consider offers.
So we knew about that 4-year offer, and we've talked about that, right? And you understand that would look like voluntarily pleading true to the judge, but going agreed to the punishment. Correct?
Correct.
And then the third option would be to go involuntarily plead true to the judge, but to go without a resolution where a judge would be deciding what the potential punishment would be after that. Sorry, you have to speak out.
Yes.
And you understand that if you voluntarily plead true, that would be enough to revoke your probation.
Yes.
And then if judge does revoke your probation, then he could sentence you anywhere within the range of punishment for a third-degree felony because you were on deferred. And you are choosing to go to judge and voluntarily plead true. Is that the?
Do you need a few minutes to talk about it and think about it?
I mean, I want to get this,
Well, I don't rush it. There are some things here. Do you need a few minutes to talk to her about the options so that you know them, so you don't talk about them in front of everybody?
I mean, I don't mind talking in front of everybody.
Judge, I feel like we have talked about all of
We
the
talked
options.
about it, Judge.
Oh, okay. All right, and you had enough time to think about it? What direction you want to head?
But they've only came at me with one offer from day one.
Well, I mean, that's the way it may be.
That's the only offer you're gonna get.
That's their domain. That you have to consider it. You have a reasonable amount of time to consider it, and those are your options. You can either accept the deal or or not, depending upon what you plead to, then I am the decision maker in a motion to revoke probation. You don't get a jury.
Well, Judge Stevens, I just want to say, while I was going through psychosis
Hold on,
from the arrest.
hold on. But the first step is
What
which,
option?
yeah, what option?
Proceed on.
Then you can have a chance to explain and she can,
I just want to go and handle it today. So
sir,
I just want to handle this today
okay, in what way?
with,
Do you want to, are you willing to accept that deal?
No, I don't
Or
accept
reject that? Then
Reject
you're
it.
gonna have to come to me.
not from you.
Oh,
That looks like either having a contested hearing or pleading true voluntarily to the judge.
I'll plead true voluntarily to the judge.
Okay,
and then, okay, and then each side gets to sound in to add any additional information that I will consider, and then I will make the decision, and then that's it. You're gonna have to live by it. You're looking at a third-degree felony, no less than 2, no more than 10 years confinement in prison. Or I could revoke your probation, sentence you up to 10 years in prison, and place you on regular probation. Or I could continue you on deferred or unadjudicated probation. Those are pretty much the options. All right. Anything else on that?
thank you.
All right. Well, here's what I would do. I need to take a couple of minutes just for a meeting.